In this session of That's a Good Question, we are going to take a look at a question dealing with trusts that has recently been posed by one of our Knowledge Shop members. We receive lots of questions through the Knowledge Shop help desk dealing with trusts and issues relating to taxation of trusts. And this particular question raises an issue that causes a lot of confusion. The situation we have here is the client has a unit trust and two individuals each own 50% of the units. The trust deed suggests that all distributions of income and capital are based on the number of units held by the unit holders, and there is no scope for the trustee to change the percentages. So the question is the trustee really required to make annual trust distribution resolutions to ensure that the trustee isn't taxed on the taxable income of the trust at penalty rates if the unit holders hold fixed interests in the trust? And that is a really good question. And the reason partly why that's such a good question is the answer can go both ways. The short answer anyway, is it depends. It depends on the trust deed. And there's actually a case that dealt with this issue going back a few years now where there were multiple trusts and the ATO and the taxpayer were arguing over whether the unit holders were taxed on the income of the trusts for the year. Now, the final outcome of that was it depended. In some cases, the unit holders were automatically presently entitled to the income of the trust at the end of the year, even though the trustee hadn't passed or made any resolutions towards the end of that year. And that's because the trust deed ensured that the beneficiaries, the unit holders, were presently entitled to trust income at the end of each year. Now, the trustee could override that by accumulating income, but they hadn't done that. On the other hand, some of the trusts in the trust deed did not have those automatic distribution or entitlement clauses. The trustee had to actually take some steps in order to make those unit holders presently entitled to the income for that year. And basically what that case showed us was that there's a distinction between having units in a trust which give you an entitlement to a fixed percentage of income and capital and being entitled to that income or capital right now. They're two different things. One looks at percentage, one of them looks at when do you get it. So generally, we tend to find, probably more often than not, the trustee will still need to take some action in order to ensure that the unit holders are presently entitled to income for a particular year. And if the trustee does not do that, then basically the default position is that the trustee gets taxed on the taxable income of the trust, generally at penalty rates, and we're normally trying to avoid that. But that won't always be the case. Some trust deeds will ensure that the unit holders are presently entitled to all of the trust income by default each income year, therefore would be assessed on that unless the trustee does the opposite and decides to accumulate some of that income for the year. So it's a great question because it really depends on the situation. We really need to go digging. Now, it's a good question as well because it is a relevant issue not only for unit trusts that have kind of fixed percentages, and there's often confusion around that, but also in other contexts. For example, deceased estates, testamentary trusts. There's often confusion over how do we know whether it's the trustee or the executor who is going to be taxed on the trust income, or will it be beneficiaries who are taxed? And it comes back to this, again, this question of present entitlement. Is present entitlement something that requires action from the trustee or the executor? Often it will. Or is it something that happens automatically under the trust deed or other trust instrument? So regardless of the type of trust you're dealing with, if your aim is to ensure that it's the beneficiaries who are taxed on the taxable income of the trust, not the trustee at penalty rates, then have a look at the trust deed or trust instrument. If it's not clear, you might need to seek some legal advice. Go back to the lawyer who drafted the deed or the legal document services provider who prepared the deed. Failing all that, maybe have a thinking about having a conversation with the trustee to ensure that it's quite clear that appropriate steps have been taken to ensure that the beneficiaries are presently entitled. And that might mean making some resolutions before the end of the relevant income year.